Serial number 3, the Registrar Administration versus Neeraj Kumar Rajak. For the petitioners, Sri Piyush Lal.
They should use a different color bond other than that. Use some harsh words.
You are for the state?
I appear for the High Court in this case, my lords, which
Patna
is
High
the
Court.
which is the appellant, my lords.
Disciplinary authority has been given power to pass order. You can impose any of the minor penalty.
My lords,
Why you are preferring this appeal?
my lords, on the issue of law that the Honorable Court was pleased to interfere on the quantum of punishment, my lords, we say that the principle on which should have...
It has not interfered. Interfered in the sense it has been, the penalty order has been set aside and the matter has been remanded to the disciplinary authority to impose, to take fresh decision. Now you have to pass a minor penalty. Otherwise, if you are imposing major penalty, you are required to follow Rule 17, which you are not followed.
Malus, there is an observation by the Honorable Single Judge Malus to that effect, where he says because it has not been followed because an explanation was asked and thereafter punishment was imposed. Whereas a memo of charge was issued, there are certain lacunas, my lords. Memo of charge was issued, inquiry was held, depositions were taken, evidence was considered, second show cause notice
Where
was...
is the inquiry report?
Malus. That is Annexure 12, page 48 of the writ petition, my lords. There are two minor defects pointed out by the office, my lords. Before coming to the merits, may I pray for some time to at least remove those? There are two defects pointed out by the office, my lords, in this case. Before coming to the merits, may I pray for some time?
If you take years together to remove the defect.
I'm sorry, my lords, my fault.
What, sorry? You are representing the High Court.
Allah sure.
You are not alert in the High Court matter. How do you expect in respect of other matters? Now only second charge is proved.
Yes, my
correct?
lords. Yes.
The language used in respect of giving explanation, the language is not correct. For that purpose, you want to impose major penalty, withholding of increment with cumulative effect.
Malas, we say that the disciplinary authority has considered the facts and the explanation and then passed an order.
Sir, he is a respondent is a newcomer. He has freshly joined. He has apologized for having submitted such a using the words in the explanation. What more you require? Impose minor penalty. What is the post held by the respondent?
He was at that point of time an assistant in Civil Court Jahanabad, my lords.
Assistant?
Assistant.
He is a fresher.
Malas, that is correct, Malas.
But you impose minor penalty and close the matter. When this court has specifically directed the disciplinary authority to pass a fresh order, nothing is there.
Malas, except for the ground, if I may urge, Malas, because there has aspersion been cast on the presiding officer, Malas. Therefore, we say that at least what the disciplinary authority did in his role, Malas, to impose a major punishment, Malas may not interfere in that, Malas. He has taken the defense, Malas, that he was a new entrant, and Malas will consider that his main defense that he was not fluent in English language. The explanation was drafted by somebody else in English language, therefore he couldn't understand the purport of it. Now disciplinary authority, my lords, has rejected it by saying that you chose to file it in English and you have not even mentioned who was the person who drafted it.
Now, why all those things is required? When he has given apology for having used the words which is not polite.
Well, as he has apologized, my lords.
And how will it make any difference if the name of the person is disclosed?
So that is his defense, that I got drafted it by
Maybe
somebody else.
he is a fresher, that you know.
He is my.
That is a
That is not
he is.
disputed.
He
That
is.
is not disputed.
No.
That means he was on probation.
No, Malas, that is not on record. He joined in 2004. This remarks were made in 2007.
We'll dismiss. Dates and events are not given. Where is the list of dates?
Malas, in the Malas, in the synopsis, my lords.
Just take down the instant petition. The petitioner has questioned the validity of the order dated 6/5/2019 passed in CWJC 23283 of 2011, by which the respondent's petition was allowed while quashing the punishment of withholding of 2 increment with the cumulative effect in a departmental inquiry, and further directed the disciplinary authority to pass to take a fresh decision in accordance with law. First, the respondent had joined service in the year 2004 while he was working in the trial court. He is alleged to have committed certain misdeeds for which he was subjected to disciplinary proceedings in a framing charge memo. 2 charges were framed, which reads as under. It is extracted on page 3 of 17. Judgment of the learned single judge. Undisputedly, the charge number 1 was not proved. The charge number 2 was proved. The inquiring officer forwarded the report to the disciplinary authority. The disciplinary authority completed the formalities of providing the inquiring officer's report along with the show cause notice, and proceeded to impose the penalty of withholding of 2 increment with cumulative effect. Feeling aggrieved and dissatisfied with the penalty order, petitioner respondent preferred CWJC 23283 of 2011, and it was disposed on 6/5/2019 with the following direction, with the following order. Page 17/17, last paragraph. Undisputed facts are that the respondent was a new entrant to the service. He was not aware of using the language while submitting explanation in a departmental inquiry. to an higher authority. That is the second charge which was proved in the inquiry. First, having regard to the fact that the respondent was a new entrant, the disciplinary authority should have taken a lenient view, which was observed by the learned single judge in the impugned order. He has also taken note of the various decisions of the court, including Supreme Court decision. Namely Chennai Metropolitan Water Supply and Sewerage Board and others versus TT Murali Babu, reported in within bracket 2014 4 SCC 108. Similarly, Raghubir Singh versus Haryana Roadways, reported in 2014-10 SCC 301, relating to doctrine of proportionality. Full stop. In the light of these facts and circumstances and the fact that respondent was a new entrant, the disciplinary authority should have taken a lenient view in imposing any of the minor penalty instead of imposing major penalty. To stop. Imposition of major penalty would affect the respondent's service in future also. Full stop. Therefore, the single judge, while quashing the impugned penalty order, remanded the matter to the disciplinary authority to take a decision in accordance with law. Full stop. Next, learned counsel for the petitioner vehemently contended that, having regard to the language employed by the respondent in submitting explanation in a departmental inquiry, he has used the word cunningly, false claim, and to save his own skin. Full stop. Perusal of the language used by the respondent, it is crystal clear that someone has drafted the explanation on behalf of the respondent for the reasons that respondent was holder of only an assistant post. That apart, the respondent has apologized, a tendered apology, which was also taken note of by the inquiring officer and disciplinary authority. Despite that, imposition of major penalty shocks the conscience of the court. Therefore, the learned single judge has remanded the matter to the disciplinary authority to take a fresh decision in accordance with law. We are of the view that there is no infirmity so as to interfere with the learned single judge's order dated so and so, passed in so and so. Accordingly, petition stand dismissed. If the disciplinary authority has not taken any decision in terms of the learned single judge's order, the disciplinary authority is hereby directed to pass suitable order of imposition of any of the minor penalty within a period of 8 weeks from the date of receipt of this order. To the above effect, the order of the learned single judge is modified. Petition stand disposed of.